If
My
you
lord,
are
she's no
online.
longer online.
Okay.
I can't see her, my lord.
Okay.
Okay. Back.
This matter is for judgment. The judgment of the court is ready and is going to be read now. This is how the judgment goes. This general form of complaint was filed on the 23rd day of February 2015 by the claimants against the defendant framed for one, a declaration that the termination of the claimant's employment for their role and participation as branch executive of the second defendant trade union in furtherance of the welfare of its members is unconstitutional, null and void, and contrary to natural justice, equity, and good conscience. Two, a declaration that the suspension of the branch executives of the first defendant branch of the second defendant trade union constitute a breach of their right to fair hearing and therefore unconstitutional and null and void. Three, an order directing the first defendant to instate the claimants forthwith and pay them all their salaries and entitlements for the period of the unlawful termination of their employment. In the alternative, the claimants claim as follows: an order directing the defendant to compute and pay the claimant their severance benefit individually forthwith. One, first claimant the sum of 2,390,749 naira 14 kobo. Two, the second claimant the sum of 1,777,477 naira. Three, the third claimant the sum of 2,056,674 naira 21 kobo. Fourth claimant the sum of 1,336,088 naira 57 kobo. Five, the sum of 200 million only as exemplary and aggravated damages against the defendant. Six, the sum of 100 million naira as general damages. In reaction to the originating process commencing this suit, the first defendant filed a statement of defense and counterclaim against the claimant on the 17th day of March 2014. Following the amendment of the claimant's statement of claim and other processes, the first defendant also amended his statement of defense and counterclaim, which was deemed properly filed on the same on the 12th day of November 2019. In reaction to the originating process, the first defendant on the first day of February 2016 filed an amended statement of defense and counterclaim as follows: A, special damages in the sum of 1,611,103,803 naira 32 kobo, being the total production and business losses and expenses suffered by the first defendant counterclaimant as a result of the strike action embarked upon by the claimant defendant to counterclaim. These special damages in the sum of 600,000 naira being the total sum incurred by the first defendant counterclaimant as cost of repairing its damaged gate and fence and resuscitating the plant, machine, and facilities damaged by the claimant to the counterclaim in the course of their protest. C, special damages in the sum of 782,520 naira 68 kobo, being maintenance contract team for being O&M maintenance contract team for the period of the strike they were idle. D, 50 million naira as general damages. E, first defendant counterclaimant against the counterclaim against the second defendant to counterclaim as follows: one, the sum of 256,534 naira being his outstanding indebtedness to the first defendant counterclaimant. Two, 21 interest for the sum 21% interest for the sum of 256,534 naira. 10% interest for judgment sum. F, the first defendant counterclaim against the third claimant defendant to counterclaim as follows. One, the sum of 166,699 naira being his outstanding indebtedness to the first defendant counterclaimer. Two, 21% interest for the sum of 166,699 before judgment is delivered. And three, 10% interest post-judgment sum. In response to the first defendant amended statement of defense and counterclaim, the claimant on the 12th day of September 2017 filed a reply to the first defendant amended statement of defense and counterclaim. It is also to note that the second defendant, despite being served with the originating process and hearing notices, failed, refused, and or neglected to file any response thereto, and never appeared or represented in court by counsel from the inception of the matter to the conclusion of hearing. This means the allegations against the second defendant are not challenged by way of defense or cross-examination. This suit commenced de novo before me on 10th day of February 2021, where claimant witness CW11 Comrade Blessed Okokon Effium testified and adopted his two witness statement on oath, which were filed on the 28th day of November 2018 and that of 12th day of September 2017. In the course of hearing, the claimant's witness tendered several documents. 17 of them were admitted and marked as Exhibit CW1A to CW1T. After cross-examination, CW1 was discharged. For the defendant, one Filian Ibadan, defendant with a Filian Ibadan testified as DW1. DW1, after identifying her witness statement on oath of 1st day of February 2016 and tendered adopted same as her evidence, DW1 also tendered documents which were admitted in evidence and marked as exhibit DW1 to DW2. Upon conclusion of evidence, DW1 was cross-examined by the counsel for the claimants and thereafter was discharged in the absence of the examination. Following the conclusion of evidence on the 5th day of October 2021, the court ordered parties to, in accordance with Order 45 of the Rules of Court, file their final written addresses. The counsel for the first claimant testified as I now goes to the case of the claimants. I shall skip reading the content. When counsel got the hard copy, they will be able to read it due to time constraint. I have also captured the case of the defendant, then the submissions of the defendant. The defendant formulated two issues for determinations. They are: one, whether having regard to the evidence of the parties, the claimants prove their case to be entitled to relief sought. Two, whether having regard to the evidence of the parties, the first defendant counterclaimant prove its counterclaim to be entitled to reliefs contained in the counterclaim. The argument of counsel on the two issues have been captured in the body of the judgment, so I will skip reading the submissions of counsel. I go straight to the case of the claimants. The claimants adopted the two issues formulated by the counsel for the defendants, claimants to counterclaim. The argument of counsel have also been captured in the body of the judgment, so I will skip also reading the submission of counsel for the claimants, defendant to counterclaim. When counsel got hard copy of the judgment, they can go through the submissions. So I will go straight to the decision of the court. Yes, I have carefully considered the processes filed, evidence laid, and submissions of counsel for the parties. The twin issues formulated by the defendant were adopted by the claimant. They will be the issues that the court will consider in determining the case of the parties. Before delving into the issues formulated for determination, I shall resolve some preliminary issues that arose as a result of the submissions of counsel. The first preliminary issue relates to submissions of the defendant that the final written address of the claimant. The submissions of the claimant that the final written address of the defendant was filed out of time and there was no application to regularize the said final address. The provisions of the rules of this court are very clear and unambiguous regarding the time within which an address can be filed. An address is very important for the parties to let the court know their position regarding the case put forward before the court. However, in the absence of any penalty provided, and in view of the case of Bode Thomas versus Federal Judicial Service Commission, which was reported in 2019 LPLR, I shall consider the non-regularization as an irregularity pursuant to Order 5, Rule 1 of the rules of this court. In the circumstances, I consider the said irregularity as the said non-regularization as irregularity, which is not capable of vitiating the processes filed before the court. The second preliminary issue is in respect of the submission of counsel for the defendant to the effect that the claimant did not call a witness in support of the facts pleaded in support of reply to the defendant counterclaim. It was further argued that a careful perusal of the claimant's amended reply to first defendant amendment statement of defense and the counterclaim will reveal that one William Stacking, the post claimant, was listed as one of the witnesses to testify before the court. The said witness did not testify to adopt the witness statement on oath. It is therefore submitted by counsel that failure of the claimants to call Mr. William Stacking to testify means that they have abandoned their evidence regarding the counter statement of defense and counterclaim. It also followed that the statement on oath in support of the claimant's amended reply to the first defendant's amended statement of defense and counterclaim was abandoned, and the reply was left bare without any evidence to prove the abandonment contained therein. A response counsel for the claimant submitted that the submission of counsel was meant to mislead the court, as the witness, as there is the further statement on oath of CW1, which was filed before the court and it was adopted by the counsel, which also contained the evidence regarding the said reply to the statement of defense and defense to counterclaim. Therefore, Mr. William Stacking is not, the non-calling of Mr. William Stacking has not affected the evidence that support the reply to the statement of defense and counterclaim. Counsel also pointed out that on 10th day of February 2021, CW1, while giving evidence in chief, identified two witness statements on oath of 28th day of November 2016 and that of 12th day of May, 12th day of July, 12th day of September 2017, and adopted same and his evidence in this case. The witness statement on oath of 12th day of September 2017 was in respect of the reply to the statement of defense and defense to counterclaim. In view of this, counsel submitted that the claimant has adduced evidence before the court in support of the reply and also the counterclaim. I have carefully perused the processes before the court. I agree with counsel for the claimant that There are two witness statement on oath of CW1, that of 28th day of November 2016 and that of 12th day of September 2017. And these two witnesses' statement on oath were adopted by the said CW1 on the 10th day of February 2021 when he testified in proof of the case of the claimants. In view of this finding, it will be difficult for me to accept the contention of counsel for the defendant to the effect that the claimants have abandoned the fact proposed to in reply to the statement of defense and counterclaim. I found and hold that the claimants have duly given evidence a record of their claim and also a record of the reply to the counterclaim, a reply to the statement of defense and also to the counterclaim. I so hold. Coming to the first issue for determination, which is whether the claimant's defendant to counterclaim have established entitlement to any of the reliefs before being sought before the court. The counsel for the parties have agreed that the tried position of the law is that he who asserts has the burden of proof. This tried position of the law has been captured by the provisions of the Evidence Act in section 131 to 134 of the Evidence Act, and the decisions in the cases of Beefy Industries Limited versus Cocoa Industry Limited, reported in 2008 Nigerian Law Report Part 1105, page 486. See also the case of Pajemiroku versus GB Nigeria Limited, 2009 5 Nigerian Law Report Part 1135, page 588. See also Itogu versus LPDC and Egareba versus Osagi. A careful perusal of the provisions of the Evidence Act and the decided cases referred to above will show that there is no doubt that the burden of proof lies on he who asserts. That is to say, the claimant who first initiated the action has the burden to satisfy the court of the proof of his case before the other party can be called upon to adduce evidence in rebuttal. That is to say, the burden of proof first lies on the claimant before it shifts to the defendant after he has adduced evidence sufficiently to establish the claim before the court. The law is also certain that a claim is circumscribed by reliefs being claimed. The duty of a claimant, therefore, is to plead only such facts and material as are necessary to sustain the reliefs and adduce evidence to prove them. He may, at the end of the day, obtain all the reliefs claimed or less. He never gets more, nor does he obtain reliefs not claimed. A court is therefore bound to grant only reliefs claimed. It cannot grant reliefs not claimed. See the case of Gabriel Atibi versus Cable Metal Nigeria Limited, reported in 2008, 5 LPLR 591 SC. It is also reported in 2008, 10 Nigerian Law Report, Part 1095, page 399. In the case at hand, claimant's claim is in the alternative. The law, as it relates to alternative claim, is that where a claimant set up two or more inconsistent set of material facts and claims reliefs on each of them in the alternative, he will be granted such relief as the set of facts established will entitle him. Thus, where claimant is uncertain whether the facts he relies on would entitle him to a relief, either in addition to or to a first relief or merely as an alternative, he can claim the subsequent relief as a further or alternative relief. A claimant who claims a principal relief and another in the alternative is to be taken as saying, on the facts alleged, I am entitled to the principal reliefs, but even if on those facts I am not entitled to it, those facts will entitle me to this alternative relief. See the case of MB Caroline Mayax Nokoyo Investment versus Nokoyo Investment Limited, reported in 2002, 12 Nigerian Law Report Part 782, page 472 SC. Therefore, when a party makes claim in the alternative, he is saying that he wants either of his reliefs. So any of the claims granted suffice for the purpose of satisfying the claim. When a court grants the main claim, the alternative claim will no longer be considered. When the main claim fails, the alternative claim must then be considered. And if found proved, the court should grant it. See the case of Bakari versus Ogundife, reported in 2021, 5 Nigerian Penal Report, part 1768, page 1 SC. Alternative claims made in case by a claimant against a defendant or defendants cannot be granted along with or in addition to the grant of the main or principal claim made by the same claimant against the same defendant. After the grant of the principal or main claim, it would be improper and injudicious to proceed with the consideration of the grant of alternative claim in the same case. For that will constitute the award of grant of double claims in respect of the same wrong or cause. See the case of Health Nigeria Limited versus Silver Anchor Nigeria Limited. See also UBN versus Pennymat Limited. See also the case of Agidimbi versus Agidimbi. See also Julius Berger PLC versus TRC Bank Limited. In the case at hand, there are two sets of claims, i.e. the main claims and the alternative claim. I shall first consider the main claim. I shall first consider the main claim, which is in accord with the principle, with the established principle of law. It is only when the main claims could not be established that the alternative claim would be considered by the court. In the amended complaint and the amended statement of facts, there are three reliefs set out as forming the main claim of the claimant. A relief 1, the claimants are seeking for the declaration that the termination of their appointment for their role and participation as branch executives of the second defendant, the trade union in furtherance of the welfare of its members, is unconstitutional, null and void. In relief 3, the claimants are seeking for an order directing the first defendant to reinstate them back to their job forthwith and pay them all their salaries and entitlement for the period of unlawful termination. These two reliefs are related and they will be considered together. As can be seen from reliefs 1 and 2, from reliefs 1 and 3 of the main claim, the claimants want the court to nullify the termination of their employment by the claimant and order the first defendant to pay the claimant their salaries and entitlement for the period of the unlawful termination and order reinstatement back to their job. The claimant reliefs 1 and 3 are hinged on the assertions that the claimant's employment was terminated because of their role and participation as branch executive of the second defendant in legitimate trade union activities in furtherance of the welfare of the branch members of the second defendant. The defendant has insisted that the defendant as employer has the right to terminate employment of its workers with no reason or for bad or for good, and once terminated, that is the end of the relationship. Although the law is settled that an employer has unfettered right to terminate the employment of his employee, and that employer need not give reason to terminate contract of employment, he only need to comply with the terms of employment and conditions of contract of employment. The motive for termination is irrelevant provided the employer complies with the terms and conditions of the contract between the parties. The employer is at liberty to terminate for good reason, for bad reason, or for no reason at all. However, with the coming into effect of the Third Alteration Act, this court is conferred with exclusive jurisdiction over employment, labor, and industrial relation matter, as well as power to apply international best practices. Consequently, the tried position of the common law stated above is fast changing. The law as it is today is that employers of labor must now give reason for termination, otherwise such termination becomes wrongful in law. The common law practice of stating service no longer required is no longer tenable in law. This is because international best practice state that every employer must give this contamination. Globally, it is no longer fashionable in labor relation law and practice to terminate employment without adducing any valid reason. See Ebere Aloysius versus Diamondback PLC, reported in 2015, 58 NLR, part 199. See also the case of Pengasan versus Shoemaker, Andre Nigeria Limited, reported in 2008, NLLR, part 29, page 164. The submissions of the defendant to the effect that there is nothing in our law that prevents employer from terminating or even dismissing a worker in accordance with the law and or the terms of contract of service between the parties. This submission seems to have overlooked the provisions of Section 43 of the Trade Dispute Act and the Section 99, subsection 6B, 1 and 2 of the Labor Act. These extant provisions of the law have provided that no contract shall be no contract shall cause the dismissal or otherwise prejudice a worker because of trade union activities outside working hours or with the consent of the employer within working hours. This court in a number of cases have interpreted the effect of these provisions of the law to mean that an employer is entitled to reinstatement where his or her employment has been terminated because of his union activities. See the case of management of Dangote Industries Limited, Pasta Plant Ebute Okorodu Lagos versus National Union of Food Beverages Tobacco Employee NUFBED. CR reported suit number NICN 2/2008, the judgment of which was delivered on 20th day of January 2009. But for this to happen, the employee must bring his case within the ambit of the provisions of Section to be within the provisions of Section 43 of the Trade Dispute Act and Section 9, subsection 6B, 1 and 2 of the Labor Act. See the case of Nupti versus Cocoa Industry Limited, reported in 2005, 3 NNR part 206 at 2018 to 2019. Of course, the question remains whether the claimant in this case have brought their case within the ambit of Section 43 and the Trade Dispute Act and Section 9, subsection B1 of the Labor Act. The claimants have insisted that it is because of their participation as executives of the branch of second defendant in furtherance of the welfare of their members that their contract of employment was terminated without compliance with the conditions of service. In answer to the claimant's position, the defendants have averred at no time or at all was there any anomaly in the policies of the first defendant that was inimical to the welfare of the claimant and all staff of the first defendant. It was also stated that no human resource policies concerning employment and training is not, that it has no human resources policy concerning employment and training that discriminate trade and is not skewed in favor of the ethnic group of the former human resource director. It was also stated that there was no victimization of any staff as there was no staff who made any complaint as alleged and no staff complaint of discriminatory treatment. There was also no controversial and lopsided hair grade policy, and that there was no withdrawal of suspension of staff loan scheme. The defendant also denied anti-labor practice, tribalism, nepotism, high-handedness, and alleged by the claimants against the then human resource director. The defendant also stated that it is a multinational company with employees from around the world. The defendant admitted holding a meeting to which the first and fourth claimants attended. At the end of the meeting, a resolution was reached and all the parties in the attendance signed except the first and fourth claimants in this case. The defendant stated that all parties were given opportunity to express themselves on all issues discussed at the meeting. The termination of claimants' employment was not on advice of second defendant. Rather, the termination was because the defendant no longer required their services and that the defendant complied with conditions of service in terminating the claimant's employment and was not in any way influenced by the second defendant. The argument of the defendant that nowhere in the letter of termination was it stated that the claimant was terminated because of their union activities is instead patronizing and laughable. This is because there is no employer of labor who would ever write that he is terminating employees' employment due to trade union activities. The claimants successfully make this point, which I agree with. I now turn to the key question whether the claimant brought his case within the ambit of Section 43 of the Trade Dispute Act and Section 9, subsection 6B1 and 2 of the Labor Act. This court has long recognized that as a matter of principle, there are two main instances where the courts generally order a statement. The first instance is where employment has statutory labor or where statutory processes in disengaging a party was not followed. Here, reinstatement has always been ordered by the courts. As he said, employment is said to be protected by statute. The second is where where a worker or workers were disengaged for embarking on trade union activities. This also is because it is against statutory provision to terminate appointment of a worker for participating in trade union activities. See the management of Dangote Industries Limited, Pasta Plant Ebute Ekorodu Lagos versus National Union of Food Bearers Supra. The management of see also the case of management of Nestle PLC Ilopeju versus National Union of Food Beverages. See also the National Union of Food Beverages and Tobacco Employee Cocoa Industries. The citation have been provided and a host of other cases referred to. For the claimant to succeed in the instant case, they must, as pointed out earlier, must bring their case within the ambit of sections 43 of the Trade Dispute Act and section 9, subsection 6B, AB, and 1 and 2 of the Labor Act. There is no problem with section 43 of the Trade Dispute Act because the termination of the claimant employment is tantamount to lockout, since thereby they cannot report to work. The issue is with the provisions of section 9, subsection 6B, 1 and 2 of the Labor Act, which requires that for the trade union activities of the claimant to be lawful and valid, for which such defendant can be held liable, it must have been carried out outside the working hours, or if carried out within the office hours with the consent of the defendant. For proper appreciation, section 9, subsection 6A, B, 1 and 2 provide thus: A, no contract shall make it a condition of employment that a worker shall or shall not join a trade union or shall relinquish membership of a trade union, or C, cause a dismissal of or otherwise prejudice a worker by reason of trade union membership, or 2, because of trade union activities outside working hours or with the consent of employer within working hours. This is the extant provisions of section 9 of the Labor Act. The provision is very clear and unambiguous. Having regard to looking at exhibit CW1G, it clearly shows that the defendant has been notified of the grievances of the executives of the branch members of the second defendant in the service of the defendant. Exhibit CW1N is a letter to Assistant Inspector General of Police dated 5th day of November 2013, informing him of the industrial action, i.e. the claimants intend to embark on peaceful demonstration within the premises of the defendant on the 6th day of November 2013 by 12 noon. Section 9, subsection C of the Labor Act allows union activities so long as they are carried out outside the working hours. So by Exhibit CW1N, the claimant not act within the law when they indicated that they will embark on demonstration by 12 noon, which is within working time, and there is no evidence to show that the action of the claimants have blessing or consent of the defendant for the demonstration to take place within the working hours, that is by 12 noon. I have no doubt in my mind that claimant's action did not come within the ambit of Section 9, subsection 6B2 of the Labor Act. I so find and hold the claimants are accordingly not entitled to a reinstatement to their work without loss of salary and other perquisite of their offices. This means that the claimants have failed to prove that the termination of their employment is covered by the provisions of Section 9, subsection 6, A, B, 1 and 2 of the Labor Act, which would have entitled them to a reinstatement. Another dimension to the claimant's claim on termination is that another leg of the prayer for regarding this termination is this, as stated by the claimant, that the termination of their employment, apart from being based on their trade union activities, the defendant did not comply with the conditions regulating their employment. Exhibit CW1A is the conditions of service. The claimants have stated that the termination was done in violation of the principles of natural justice. This means that the issue of this raises the issue of audi alteram fatem. From the letters of termination of appointment, it is deducible that the claimants were never given any fair hearing or informed of their offenses before termination of their employment. The reason is because the letters of termination stated that the defendant no longer needs the claimant's services. This, as pointed out earlier, amount to wrongful termination of employment. Furthermore, Article 7.15 of the Exhibit CW1A has stated in unambiguous terms that if a confirmed employee is to be terminated, he is entitled to be given 1 month salary, one month notice of termination or payment in lieu of notice. It is evidence from the letter of termination Exhibit C that the termination of claimant's employment was without any notice. In the circumstances, the claimants are entitled to payment of their 1 month salary in lieu of notice. However, from the abandonment in the pleadings and evidence contained in the witness statement on oath, the claimants have not been paid their 1 month salary in lieu of notice as stipulated in the conditions of service of CW1A and the various letters of employment of the claimants. The law is that payment of salary in lieu of notice must be made contemporaneously with the termination. See the case of Chukuma Shell Petroleum relied by the claimant. Paragraph 61 and 62 of the case of Malam Oyeshola Ogule versus Sterling Bank PLC are reported suit number NICM/LA/430/2014. The judgment of which was delivered on 24th day of May 2018. See also Daudu versus Aziz and host of other cases quoted mentioned in the body of the judgment. The fact that the defendant did not make payment in lieu of notice contemporaneously with the termination also means that the termination was wrongful. See also the case of Yunusa versus Adewale Adewo Pepe versus MTN Nigeria Limited Sufra. Having thus made a finding that the termination of claimant's employment was wrongful on 2 grounds, i.e., in not giving 30 days notice and in payment of of salary in lieu of notice being contemporaneously with the termination, the claimant is entitled to damages for wrongful termination, which is a case law authorities have put it that payment should be for the period for which the claimant is entitled to notice. The law is very clear that where termination is an employment, its wrongful damages is awardable. The common law position was that the quantum of damages or measure of damages is the sum payable in lieu of notice. See Yunus Adewale versus MTN Communications Sufra. See also the case of OAC Pensions Limited versus Olayinka, reported in 2015, LPLR 43207CA. All this means by going by the case of Yunus Adewale Sufra, that the claimant measure of damages is payment of salary in lieu of notice by payment of salary, 1 month salary in lieu of notice. I shall now consider relief 2 of the main claim, which is for declaration that the suspension of the branch executive of the first defendant breached the second defendant trade union constitute a breach of their right to fair hearing and therefore unconstitutional, null and void. The claimants made the claim for this declaration on the issue surrounding their refusal to sign a resolution reached at a meeting because they allege that they were not given opportunity to express their view and there is no absence of clause for non-victimization. The second defendant against whom this relief was being sought did not despite being served with the originating process, commencing this suit, file any process or enter appearance in defense of the action. This means the second defendant has no interest in defending the suit. However, since the relief being sought is declaratory in nature, the claimant is bound to succeed only on the strength of his case and not on the weakness of defense or admission or non-filing of defense. For the claimants to be entitled to declaration, he must do that by adducing concrete, credible evidence. See the case of Dumes, Nigeria Limited versus Wokoba and others. See also the case of Bello versus Eweka. See also the case of Motuashe versus Sorube, which have stated that for praying for declaratory reliefs, the claimant will have to rely on his own case and his evidence in proof and not on the weakness or admission in the defense. See also the case of Sadios or BDK and others versus Minister of Land and Housing, Urban Development. The claimant by their evidence as shown in Exhibit CW1J and Exhibit CW1R, they were queried by the second defendant and they responded to the query by Exhibit CW1H. It was after the second defendant has considered Exhibit CW1H that Exhibit CW1 case letter of suspension was issued to the claimants. So where is the denial of fair hearing? This court cannot act as an appellate court to the decision to suspend the claimant as it was done by Exhibit CW1K. This court can only look at the procedure adopted. If it violates fair hearing, then a declaration to that effect can be granted. I am satisfied with the exhibit tendered. There is no proof of violation of fair hearing. Reliefs 2 fail and same is hereby refused. Having found some part of the main claim proved, that is to say that the claimant's termination of employment was wrongful, the claimants have lost the right to have the alternative claim to be considered, as doing so may amount to double compensation, which the law frowns at. The second issue for determination is whether, having regard to the evidence of the parties, the first defendant claimant to counterclaim has proved its counterclaim to be entitled to reliefs contained in the counterclaim. It is the law that a counterclaim, though incorporated into the claimant's action, it is an independent and separate action to be proved by credible, cogent, compelling evidence by the defendant. Therefore, the defendant claimant to counterclaim has the onerous task of first establishing his claim before the burden of proof will shift to the claimant in accordance with provision of section 131 to 134 of the Evidence Act. From the reliefs being sought in the counterclaim, the claim in the counterclaim being monetary in nature are claims for special damages, which by the case of NNPC Clippo Nigeria Limited and 7F Company Nigeria PLC versus Augustus must be specifically pleaded, particularized, and specially proved with credible and compelling evidence to the satisfaction of the court. The fact that it appears to be admitted does not relieve the party claiming it of requirement of proof with compelling evidence. The claimant must prove not only the entitlement to the sum, but how he/she came by the counting of the sums. The proof of entitlement is obtained by reference to an instrument or document that grants it. By the decision in Mr. Mohammed Dungus and others versus ENL Consortium reported in 2015-60 NLR 3208, page 39, oral the proof is not by oral evidence of claimant, except if corroborated by some other credible evidence before the court. In the case of Mr. Joseph Akinola and others versus Lafarge Cement Wafco Nigeria PLC, 2015 LPLR 24630 CA, specifically, this case specifically cautioned against reliance on oral contract or evidence as proof of such entitlement. In the instant case, the dependent claimants to counterclaim have claimed reliefs, various sums of humongous money in their counterclaim against the claimants, defendants to counterclaim. This was as a result of strike and also the loan purportedly granted to the second and third claimant. The evidence of the defendant claimant to counterclaim is the evidence the defendant counterclaimant is relying in proof of the counterclaim is the evidence of DW1. Who by her paragraphs 1 and 2 of the witness statement on oath has stated that she works in the Human Resources Department of the claimant. It is to be noted that in proof of claim, no particular number of witnesses is required for proof of any fact unless expressly prescribed by law. Thus, in civil case, the claimant can establish his case on evidence of a single witness without confirmation by the testimony of another witness. However, where a party's case is hinged or predicated upon testimony of a particular witness, and that witness is not called, the case of that party will be fatally affected. What is required is for a party calling witness to call a vital witness whose testimony is credible and can be relied on by the court in reaching its decision. Therefore, testimony of a vital witness is very important to success of a case before the court. See the case of Okochi versus Anima Koi. See also Alao versus Akano. See also Odutola versus Mabungunje. See also Edosa versus Ehiwema. All citations have been provided. In her witness statement on oath, DW stated that she is an employee of the defendant claimants to counterclaim and work with the first defendant claimant to counterclaim as Assistant Industrial Relations Human Resources Manager, and the facts deposed to are within her personal knowledge. However, there is nothing in the deposition or in the oral evidence to show how the facts becomes within her personal knowledge. In fact, the evidence of DW1 under cross-examinations has debunked the claim of having personal knowledge of the facts giving rise to this suit. DW1 has told this is because DW1 has under cross-examination told this court that she left office while demonstration was on because she was pregnant. This piece of evidence from the mouth of DW1 has betrayed her claim of having personal knowledge of the facts in dispute. The evidence of DW1 shows that there was a strike that runs for 7 days, and there was a total shutting down of machinery and power plant, which crippled productions that led to losses. The big question that beg for answer is how did DW1, who left office when the demonstration began, came about what transpired in the office for 7 consecutive days when she has left when the protest has started because she was pregnant. Having regard to the nature of the evidence required for proof of special damages, I quite agree with the claimants, defendants to counterclaim that there is no concrete, cogent, and compelling evidence adduced by the defendant claimant to counterclaim in proof of the various humongous sums of money being claimed in the counterclaim. The defendant claimant to counterclaim has averred that it had maintenance contract with other companies, and the workers in charge of the said maintenance remained idle for the period of the strike, which led to huge losses. However, none of the staff in charge of the maintenance rendered idle by the said strike were called to testify, and DW1 is not one of them, as her paragraph 1 of the witness statement of oath has clearly stated who she is and where she works with the defendant. It is clear to me that evidence of DW1 is hearsay and is unreliable, as it cannot be accorded any credence. Therefore, I discountenance the evidence of DW1 due to lack of weight to be attached to it, as it is hearsay. It cannot prove the claim for special damages by the defendant claimant to the counterclaim. On the indebtedness of second and third defendant to the counterclaim, there is no iota of evidence adduced to support the quantum being claimed. Same failed and is hereby refused. The indebtedness, the counsel has not told the court the exact amount, has not tendered any agreement as to the granting of the loan, which the said second and third defendant are still indebted. It is to be noted that when an artificial entity acts through its human agent, and so they reserve the right to choose whoever it wants to testify on its behalf. The truth is that it takes a huge risk if it calls someone as a witness such as DW1, who was not a privy to the facts upon which the evidence is given. This court has cautioned employers on this point severally C, the case of Pastor Mrs. Abimbola Patricia Yakubu versus Financial Reporting Council of Nigeria, and another unreported suit number NICN/LA/673/2013, the judgment of which was delivered on 24th day of November 2016. See also Mr. Charles Ugele versus Accent Bank PLC. See also DW1 in the instant case has told this court that she left office when protest started because she was pregnant. From this testimony under cross-examination, there was no way DW1 can have any personal knowledge of the facts as she claimed in paragraph 1 and 2 of the witness statement on oath. Therefore, the pieces of evidence of DW1 fits the hearsay rule, and so will be discountenanced by this court. What this means is that the narration of events by the claimants regarding strike action is the correct version. This means that the strike was for only 1 day, and there was no evidence, there was no violence, no destruction, or shutting down of machinery and plant. And power plant by the claimants, defendant to counter claimants. This is also supported by the abatement that the defendant have military personnel and paramilitary personnel stationed at his company to protect the property, lives and properties, and also machinery and equipment. If there are military and security personnel stationed at the premises of the defendant, how can the claimants, who are civilians, have access to the premises and even vandalize or cause destruction? More particularly when considering the fact that the period within which the defendant, claimant to counter claimant, has stated that the strike took place or the demonstration took place, which is from 29th day of January 2014. As at that period, the claimants have already lost their job. They are no longer employees of the defendant claimant to counter claim. In such scenario, how can the claimants have access to the premises when they are no longer in the service of the defendant? The defendant claimants to counter claim also has about that the defendant refused to come and pick their letters of termination and check for payment of their entitlement. All this goes to show contradiction in the evidence of the defendant regarding his claims for special damages, claims for destruction, or stoppage of production. I do not believe in the evidence of the defendant claimant to counter claim that such kind of destruction has ever taken place in its premises or with its flanks, more particularly when there are security personnel that are in charge of providing security for the safe period. And there was no evidence that the defendant claimant to counter claim has ever reported the claimants to law enforcement agencies concerning the destruction which they have caused, or there was any arrest regarding such protest or violent protest as the dependent claimant to counter claim wants the court to believe. I entirely disagree with the defendant on the issue of destruction of machinery or shutting down of land or reduction in the production. In any event, strike per se is a legitimate weapon and is allowed by law for workers to engage in strike. In the circumstances, I do not see how exercise of legitimate rights will give the defendant claim to counter-claimant right to action to claim special damages from claimant defendant to counter-claimant to whom the law has granted unfettered right not to engage on strike All that the defendant need to do is not to pay the salaries of the claimants for embarking on such strike. There was no even evidence before the court that the claimants were paid during such period. In the circumstances, the dependent claimant to counterclaim failed to prove any of the claims in the counterclaim. On the whole, I find for the claimant's defendant to counterclaim that the termination of their employment for service no longer required and non-payment of salary in lieu of notice contemporaneously with the terminations as amounting to wrongful termination of employment, and they are entitled to payment and each of them is entitled to payment of 1 month salary in lieu of notice for termination. The defendant's claimant to counter-claimant has failed to prove his claim for various humongous sums of money against the claimant defendant to counter-claim. The defendant is hereby ordered to pay 1 month salary to each of the defendants for wrongful termination of their employment. The sum of 2 million naira cost is also awarded against the defendants claimants to counterclaim in favor of the claimant's defendant to counterclaim. Before I end this, before ending this judgment, let me say that this suit was brought to fore this suit has brought to fore the need for counsel while preparing the case for his client to be circumspect in putting appropriate claims before the court and necessary pleadings for proof of the case. Counsel should always remember that the court is not allowed to engage in scouting for necessary pleadings, as that is the job of the counsel. The present suit has demonstrated that if counsel has brought appropriate claims with the appropriate pleadings, the judgment of the court would have been more beneficial to the claimants. However, this court must heed to the advice of His Lordship Tor JCA of blessed memory, as he put it in Chief James Onyewuke versus Modusule, LPLR 9084CA, on issue of pleadings. His Lordship stated that a trial judge should not embark on voice seeking to repair the damage caused by counsel in failing to plead material facts necessary to obtain judgment in the temple of justice, since courts are not carpenters' workshops where judges toil to mend defects in pleadings. Accordingly, it is not the duty of this court to refer reliefs being claimed by the claimant, and the relief shall accordingly be discountenanced. End of quote. Judgment is entered accordingly. The monetary aspect of this judgment shall be paid within 30 days, failing which 10% interest shall apply. Judgment entered accordingly.
As the court pleases.
God bless it. My Lord, we are grateful for the judgment.
Yes. Thank you.
Thank you, my Lord.
Yes. Thank you very much,
My Lord.
Counsel.
Yes,
Yes.
Lord, we are also grateful for the
welcome.
defendant. Thank you very much. My Lord, may we now announce our appearance for record purpose.
Okay. Yes. You can
Julius Idigbe.
Julius Idigbe.
My Lord, wait, A.O. Enabulele.
Was A.O. Enabulele.
Yes, my Lord, and Idara Andy.
Idara who?
Andy, A-N-D-Y.
Idara Andy.
Yes, my Lord. My Lord, for the first defendant.
Okay.
We are grateful for the judgment.
Thank you very much, Counsel. We have come to the end
Thank you, my
of
Lord.
the virtual sitting.
Yes, my
Yes.
Lord.
Administrator, you can end the sitting.
I have not, that's what I'm trying to do.